myself Jatin Sapra, and through this video today, Wallah brings you the concept and MCQs of orders of the CPC relevant for UP Judiciary examination. So, without wasting any further time, I will be starting with the orders relevant to the CPC in lieu of UP Judiciary examinations. So, let's start. Let's start with order number 1 to 5. See, in order number 1 to 5, it is written about parties to the suit. Order number 1 is parties to the suit. All right, parties to the suit. See, parties to the suit, it all deals about necessary parties, misjoinder of parties, non-joinder of parties, and basically what which people should be there in a suit, right? So, parties, the kinds you can say it is necessary party, necessary party. Second shall be concept shall be non-joinder of parties. Third shall be misjoinder of parties. See, necessary parties are those parties that are necessary for clear adjudication and against whom relief is sought, right? Second is non-joinder of parties, means the plaintiff has not joined a necessary party, not joined a necessary party. Third is misjoinder of parties, that is the plaintiff has joined a party which is not relevant to the suit or neither any relief is claimed again against that party. So that is what necessary party, non-joinder of party and misjoinder of party is there. Next shall be cause of action. Cause of action. Now, cause of action says an action of which defendant is answerable to the court. The action for which defendant is answerable to the court. Right. Now, with these parties, a suit can be there. Now the next concept shall be representative suit. Representative suit is, as the name suggests, this is a suit filed on behalf of someone or many people, right? Filed by or against representatives. All right. So इसका कंडीशन है, इसका कंडीशंस देख लेते हैं। Condition is first is there shall be numerous parties. Second condition is they must have the same interest in the suit. Same interest. All right. Third, there shall be a permission of court. With permission of the court, we mean that the representation, the proper parties should take the permission of the court for allowing the representative to represent them. All right. Now, fourth, again, since there is permission of the court, there must be a notice. Notice to everyone by court. See, now the problem arises if there is a representative suit. Then, for example, someone is representing me in court. Whether if the matter goes against me, whether I can file the same matter in my name now. So the principle of res judicata applies here. Res judicata applies. All right. So this is the conditions that has for the representative suit. Next shall be next concept is summons. These all concepts are under order 1 to order 5. So summons are summons is a document sent by court, right, calling upon the other party, opposite party to appear, right. Next is the essentials of the summons. The essentials to them are it should be signed by judges. Next shall be sealed by the stamp of the judge. Right. Third is the summons should be accompanied by a plaint. Right. When a summon goes, then see after service, defendant appears, all right, and files his WS within 30 days of receiving summons, right? So this is what in shallow it was order 1 to 5. Now I'll start with the MCQs and I will explain you all the concepts which are remaining in these orders. MCQs. First, which provision of the Code of Civil Procedure provides that one person may sue or defend on behalf of all in same interest? Now, the answer to this is Order 1 Rule 8, that is talking about representative suit, essentials, again, one person sue or defend same interest, right? All right. So this is also an essential. Next, representative suit under Order 1 Rule 8 CPC may be permitted by the court when numerous persons are parties in another suit, numerous persons belong to the same family, numerous persons have the same interest in one suit, or none of the above. The answer to this is basic answer. Numerous persons have the same interest. When numerous person parties in another suit, then it doesn't amount to representative suit. Second, the numerous person belong to same family, then also it won't be a representative suit until and unless the interest is same, right? Next shall be, which one of the following is not required in filing a representative suit under Order 1 Rule 8 of the CPC? Numerous parties, same interest, leave of the court, written permission of those who are being represented. So the answer to this is under not required, right? Not required. Numerous parties are to be required, same interest should be there, leave of the court should be there, written permission of those who are being. See, written permission is not required, but the notice shall be issued to each and every, right? Fourth, which is the case of which notice to all the persons interested in a representative suit need not be given: abandonment of the suit, withdrawal of the suit, recording of compromise in a suit, addition of a new defendant in a suit. So the answer to this is addition of new defendant in a suit. So, for example, representative suit says representative suit, one is representing 20 people. So wherever there is abandonment of the suit against one or all, the it is to be necessary that a notice to be given to all of them. If a withdrawal of a suit is there against only one person or by one plaintiff or against other defendants, then also all the notices shall be given. all notices to everyone should be given, and recording of a compromise, again it should be given, a notice should be given. Now addition of a new defendant does not require the notices to be given to all, right? Second, a suit filed in a representative capacity can be withdrawn, compromised and amended, etc. by the plaintiff without notice to all the interested persons. See, it's withdrawn, compromised and abandoned. That is without notice to the, after notice both can be either or be. No, the answer to this shall be after notice to all the persons interested. See, after giving, just for example, I am representing three of you, right? So whenever I want to take a step of withdrawal of proceedings, compromise in a proceeding or abandonment of proceeding, I have to give notice to you all that I am doing this because it decides the rights and liabilities in finality. So it is important for me to know or to tell you that your suit is being withdrawn against so and so or whatever defendant number. It's compromised by some defendants or abandoned, right? So it should be a notice to be given to all the parties that I am representing. Next, sixth is under the Code of Civil Procedure, where a person who is necessary party to a suit has not been joined as a party, it is a case of misjoinder, non-joinder. It is not joiner, so it shall be non-joinder. Means doesn't join. Misjoinder means wrongly. All right. Next shall be 7. On account of misjoinder or non-joinder of parties, under Order 1 Rule 9 of the CPC, the suit is liable to be dismissed, cannot be dismissed, may be dismissed or may not be dismissed as per the discretion of the court, and none of the above. The answer to this is C. Again, for misjoinder and for non-joinder of parties, the suit is liable to be dismissed, but now a fair opportunity shall be given. Fair opportunity to implead party, right? If fails, then liable to be dismissed. Answer to this is cannot be dismissed at the first instance, obviously. Now I have chosen this option because it is closest to the question asked. Next shall be a suit may be defeated due to non-joinder of a proper party, misjoinder of a necessary party, non-joinder of a necessary party, or misjoinder of a proper party. The answer to this is as simple: non-joinder of a necessary party. It says a suit may be defeated, meaning that the suit is already in trial and it is at the final stage. Since there is no proper party or non-joinder of necessary party, the relief claim cannot be granted against who is not being impleaded. So the suit will defeat. Next is under CPC, where a person who is a necessary party to a suit has not been joined as a party. It is a case of, again, non-joinder. The answer to this is non-joinder of parties. Next, under which provision of the Code of Civil Procedure the parties can be struck out, added or substituted? The answer to this is Order 1 Rule 10. It is given under Order 1 Rule 10. See what Order 1 Rule 10 is. It says you can add a party, you can strike out a party, or you can substitute a party. Means अगर LRs हैं, for example, a defendant or a plaintiff expires, so to fill his shoes. You can move an application under Order 1, Rule 10, seeking permission to add, strike, or substitute a party. So the answer to this is Order 1, Rule 10. Next, a necessary party is one in whose absence no order can be made effectively. Absence an order can be made but whose presence is necessary for the complete decision of the case. Only B is correct. D, none of the above. The answer to this is absence, in whose absence no order can be made effectively. See, again, the principles of CPC, that is fair trial and both parties should be given a chance to be heard. So, until and unless all the necessary parties are present before the court cannot do anything. So, the necessary party should be made a party first. Second, it should be appearing until and unless it is moved ex parte. Next shall be mark the incorrect statement in context of a representative suit. If the person suing or defending does not proceed with due diligence, the court can substitute in his place any person having the same interest in the suit. The suit can be withdrawn, compromised, or abandoned by the plaintiff after giving notice to all the person interested. This is what I think is correct. Any decree passed in such a suit is binding on all the persons interested. Res judicata is not applicable to such a suit. See, res judicata is applicable. So this is a wrong answer then. So the answer to do this, mark the incorrect statement. Sorry. Again, see, when we are reading a question like incorrect, correct, in last one of the questions also, I have made a mistake that I am saying that the answer is B, but I'm correcting C like this. In this question, what I did was it is a very simple question. Necessary party has not been joined as a party. That means non-joined. But when I was taking the answer, I ticked option C, both A and B. So you have to be very attentive while you are writing your judiciary examination or attempting your question paper. Next shall be here mark the incorrect statement. What I did here was I was marking the correct statement, but after reading the question again, mark the incorrect. Incorrect statement is this. Res judicata is applicable to such a suit. All right. So next, where a plaintiff omits to sue in respect of or intentionally relinquish any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. The genesis of this principle lies in Section 15 of the Indian Evidence Act, Section 11 of the Code of Civil Procedure 1908, Order 2 Rule 2 of CPC, Order 1 Rule 2 of CPC. The answer to this is Order 2 Rule 2 of the CPC. See, where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. For example, A sold goods to B, sold goods to B. All right. Now, worth rupees 1 lakh. Right. So now A files a suit of 50,000 rupees. A files for 50,000 rupees of the same transaction that he was liable, that he was getting 1 lakh. So now he cannot come again and say कि गलती से रह गया था और मैंने relinquish कर दिया था तो दोबारा नहीं आ सकता कोर्ट में saying कि 50 नहीं 1. So you have to approach the court with all the facts on the very first instance only. Next, 14th. As per Order 2, Rule 1 of CPC, every suit shall, as far as practicable, be framed so as to afford ground for final decision to prevent further litigation, both A and B, and none of the above. The answer to this is afford ground for final decision, yes. To prevent further litigation, yes. Both A and B, yes. Now, what Order 2 states is frame of issues. Now, issues are being framed in the matter because to narrow down the dispute between the parties and to know what evidence is to be led and to help the judge to know what is the actual dispute and on what grounds and what points he or she has to give a judgment. Again, if there are no issues framed, then what happens is कि जो भी सब कुछ मतलब ऐसा हो जाएगा सब कुछ आपको प्रूव करना पड़ेगा. It doesn't narrow down the dispute if issues are unframed. So to prevent further litigation and to give a ground for final decision, framing of issues are important. That's why the answer is both A and B. Next, Order 2 Rule 2 CPC does not apply to application for execution, writ petitions, both A and B, and none of the above. The answer to this is both. Application or writ petitions may not, it's not there because it's only an application of execution means trial has conducted and trial has reached its finality. No appeal is there, so no question of framing of issue. And second, writ petitions is filed on an issue that is there, and in writ petitions mainly evidence is not required or everything is documentary or documented that is admissible. Third, according to Order 2, Rule 3 of CPC, a plaintiff may unite in the same suit several dash against the same defendant. Now, several cause of action, yes. Option A is issues, B is claims, C is cause of action, D is debts. Answer is C, cause of action. Now see, if there are same parties, A and B, now what I do is I file a suit for recovery of rupees 20 lakhs. Now what I did was मेरे को 20 लाख का लोन, मेरे को 20 लाख का उससे सामान मैंने उसको बेचा है, रिकवरी 20 लाख की है. So what has happened, 5 मैंने उसको 4 बारी सामान भेजा. A sent goods to B 4 times of 5 lakhs each. So he can join 4 cause of actions and claim rupees 20 lakh in lieu of that, right? So Order 2 Rule 3 gives that power to the plaintiff. Next, A lets a house to B at a yearly rent of rupees 500. The rent for the whole of the years 1905, 6, 7 is due and unpaid. A sue B in 1908 only for the rent due in 1906. A sue B only for 1906. That means he has omitted or relinquished the rent of 1907 or 1908. 1906, 1905 and 1907. A can afterwards sue B only for the rent of no. A can afterwards sue B only for the rent of afterward no. A can afterwards sue B for the rent due for no. A cannot afterwards sue B for the rent due in yes. Correct. See, we have learned that once a claim has been omitted or intentionally, unintentionally omitted or relinquished, you cannot come back to the court and say कि ये जी ये रह गया था. So what was the purpose? to put an end to litigation and to narrow down the dispute. Next, A lets a house to be at yearly rent of rupees 10,000. The rent for the whole of the year 2000 to 2008, 6 to 2008 is due and unpaid. A sues B in 2009 only for the rent due of 2007. So the answer to this is A cannot afterwards sued for rent of 2006 or 2008. So the answer to this is again D. Next, 19th. A lets a house to be at yearly rent of rupees so and so. The rent for the year itna is due and unpaid. A sues B in 2018 only for the rent due for year 2016. Whether A can afterwards sue for the rent due of the year 2015 and 17. Yes, no, if he shows good cause, none of the above. Now, in the previous two questions, we have said he cannot sue for the same, but here the options are different. The answer to them will be also different. Let's see. The answer to this is yes, no, or if he shows good cause. Whether if he's showing good cause will entitle him to file a case where he has omitted or relinquished his right to recover rent of 2015 and 17? No. The answer is here also no. In no circumstances you can file a case that you have for the claim that you have omitted or relinquished. All right. Next, which provision of the code deals with joinder of cause of action? The answer to this is Order 2 Rule 3. We have already discussed the same. Different different cause of actions may be joined in one suit if parties are same. Next, 21st. Which of the following tests are to be applied in cases where the plea of bar of suit under 2 Rule 2 is raised, where the cause of action is in the previous suit and that in subsequent suit are identical? Next is whether the relief claimed in the subsequent suit could have been given in the previous suit on the basis of the pleadings filed in the suit. Whether the plaintiff omitted to sue for a particular relief on the cause of action which had been disclosed in the previous suit or all of the above. The answer to this is all of the above because what the question says is where the bar of suit under is there, cause of action same, subsequent the cause of action in both the suits are same, relief claimed is same, and third is omitted. अगर omitted है तब भी वो उसको res judicata क्योंकि apply करेगा, then also there is a bar. So all of them. Next, a plaintiff cannot unite several cause of action in the same suit. It can. It can. Next, can unite several cause of action in the same suit against the same defendant? Yes. Unite only some cause of action, unite only questions of law. Answer to this is very simple. B, can unite. Yes, it can unite different cause of action if the defendant is sick. 23rd, which of the following is not a ground for the court to order separate trials under Order 2 Rule 6 CPC? Delay in trial, embarrassment of the trial, inconvenience, none of the above. The answer to this is none of the above because in any of these cases, the court cannot order separate trials. Next, multifariousness means misjoinder of cause of action, misjoinder of parties, non-joinder of parties, misjoinder of cause of action as well as parties. So the answer to this is in simple words is D, misjoinder of cause of action as well as parties. Next, the plaintiff wants to claim some reliefs in a subsequent suit. He requires leave under which the following provision of the Code of Civil Procedure. Section 82 clause 2, 20, order 2 rule 2 point part 3, order 1 rule 8. So the answer to this is order 2 rule 2 part 3. Now, some reliefs in a subsequent suit. Some relief, matlab, again, in a subsequent suit, when issue is framed and the relief is different, the issue res judicata shall apply, and the court and the party has to take permission of the court to file the subsequent suit. Issue res judicata shall apply, right? Next, several persons can be joined as plaintiffs in cases where right arises out of the same act in favor of such person, where any common question of law is involved, both A and B, and none of the above. Answer to this is both A and B. Why? Because same act hai in favor of such person, and where any common question of, see, you must have heard at many times that there are many petitions that have been clubbed together because the question of law is same. So that is why, to for the convenience of the judgment also and the court also, facts are different but the question of law is same, then it can be clubbed and plaintiffs can be joined together. Next, which of the following deals with service of process on pleader in the Code of Civil Procedure? Which of the following deals with the service of process? Right, service of process is basically service of summons. The answer to this is order 3 rule 5, order 2 rule 2, 7 rule 3, or 4 rule 8. The answer to this is order 3 rule 5. Now we will see service of summons, right? Now, service or summons can be of different ways. First is personal or direct service. Personal. See, service can be personal or direct, which the rules that have the provisions of the same are rules 10 to 16 and 18. Next is service by court. This is dealt in order 5 rule 9. Rule 9. This is also order 5. Next. Next is service by plaintiff. This is rule 9A. Next, service by post. Right. Now, these are 4 kinds of services. Now, what if all these fails? What if all these fail? Then there is substituted service. All right. What if all fail? Then it is a substitute service dealt under rule number 17, 19, 20. All right. Next, see what the modes of substituted service I'll discuss in the next slides so that your concept is clear. Next, under Civil Procedure Code 1908, every suit shall be instituted by presenting a plaint in duplicate. That is 1 plus 1. 1 plus 1 to the court or such officer as it appoints in this behalf. This is provided under section 26, 20, order 3 rule 1, order 4 rule 1. The answer to this is option D, order 4 rule 1. Filing of plaint is equal to 1 plus 1. See, 1 plus 1 means 1 is the plaint and the documents. Plus 1 is only the plaint and not the documents. This is what 1 plus 1 means. Next, under Order 4, Rule 1, Sub-Rule 1 of CPC, a suit is instituted when a copy of plaint is presented to the court, a plaint in duplicate is presented to the court, a plaint in triplicate is present to the court taken the plaint in consideration. A suit is instituted when a plaint in duplicate is presented in the court. I have already discussed you with the same. This is a necessary averment or the necessary the court process that has to be followed. Next, rules as to issue and service of summons in CPC are laid down in Order 5, Order 7, Order 8, Order 11. The answer to this is Order 5. I have already explained you the summons. I will explain you the concept of substitute summons later. Next, Order 5 of CPC provides for issue and service of summons, institution of suits, pleadings generally, or admissions. Answer to this is issue and service of summons. Next, summons of a suit cannot be served by service in person on the defendant. It can be done. Sending the summons on the residence of the defendant can be done. Through publication in the newspaper can be done. Sending the summons to the friend of the defendant. This all can be done, but this is your right answer. This cannot be done. Now, publication newspaper is a form of or a type of substituted service. Type of substituted service. All right. Next, under Civil Procedure Code 1908, copy of plaint shall be attached with every summons. Is not necessary to attach with every summons. May be attached with the summons when court permits, or is attached with summons on the request of the plaintiff. No, it shall be attached with the summons. Every summons, yes. See, when you file your plaint in the court, you notice has been issued or summon is been issued by the court. Then you go to the court staff, you say that this is the summon, you have to prepare a summon and this is the copy of the same. Please send it to the party concerned. So the party, until and unless gets the copy of the plaint, how would you expect that the other party shall reply within 30 days? So you have to provide the copy of the plaint with every summons to the defendant, right? Next, a defendant under Order 5, Rule 1, Clause 1 of CPC is required to appear, answer the claim, and to file the written statement within 90 days, 60 days, 30 days, or 15 days. The answer to this is within 30 days. Service of summons. Now, 30 days statutory period है. 30 days is statutory period, plus 60 is discretionary, 90 days. ठीक है, 60 is 60 days are discretionary days, 30 days are statutory period. So the in total you have 90 days to file your WS. 30 days 100% you will be given the, it is a mandatory provision. 60 is a discretionary provision on the judge. If the judge says no, I'm not allowing you after 30 days, then your WS will not be taken on record. Next is, the court may also permit service of summons by the plaintiff in addition to service of summons by the court by Order 5 and CPC Rule 9, 9A, 10 or 11. The answer to this is Rule 10. 35, it's Rule 10. Wait, let us go back and see the concept I have written. Service by plaintiff is Rule 9A. Summons by the plaintiff in addition to summons by the court. The answer to this is, again, it is Rule 9A, because explained, I got confused between 9A and 10, but the answer to this is Rule 9A, because service of summons by plaintiff is allowed in addition to service by court. Next, thus the summons for service on the defendant can be given to the plaintiff under Order 5 Rule 9A, Order 5 Rule 9, Order 5 Rule 7, Order 6 Rule 6. The answer to this is Order 5 Rule 9A of CPC. See, 9A is service by plaintiff. Now, thus the summons. See, the funda behind summons is, when summons are issued, first step से लेके चलते हैं. Summons issued, 7 days time to file process fee, right? Process fee is PF. See, now filing of PF and plaint with court staff. This is second. Third, preparation of summons, dispatch. This is the procedure of filing of PF and service and issuance of service of PF. Now, see, 7 days, there are 7 days to file PF. So, thus the summons are summons when there is urgency of something, or the plaintiff says, I want to go with the court's person to see what is happening at the given address. So thus the summon is summons of emergency or urgency. ठीक है, अर्जेंसी है तो आप दस्ती समन्स कोर्ट से रिक्वेस्ट कर सकते हो, कोर्ट विल अलाउ the dusty summons, and within only on that day only you can get your summons ready and you can go with the court staff to deliver the same to the defendant's place, right? Next, under Order 5 Rule 9(3) of the Civil Procedure Code, The expenses for the service of summons to the defendant have to be borne by plaintiff, defendant, court, partly by plaintiff, partly by defendant. So in this, expenses of service of summons definitely is to be held by plaintiff. The answer to this is the plaintiff. Because it is my suit, I will intimate the defendant that I have filed the suit. I'll take all the care of the expenses of how to get your service done. Next, which of the following statement is incorrect? Where there are more defendants than one, service of the summons shall be made on each defendant. This is correct. Service of the summons shall be made by tendering a copy thereof signed by the lawyer. It is correct. It is correct. Third is summons for the defendant cannot be served on his servant. Defendants may empower agent to receive summons. Which of the summons for the defendant cannot be? See, जो summons होते हैं वो जाते हैं where the following is incorrect. If you see, service of the summons shall be made by tendering. See, summons of the defendant cannot be served on his servant. It is correct. Defendant may empower the agent to receive summons. It is also correct. So what about, see, these are two correct, but service of the summons shall be made by tendering a copy thereof signed by the lawyer. It is not compulsory. Whether a modern, again, so the answer odd one out here is 38 is B. It is not important that it is to be signed by the lawyer, right? So it is, the answer is B, that is, I've used the method of elimination here also. 39, where a defendant was avoiding service deliberately, the court ordered service by advertisement in newspaper, but it did not order to affix the summons in the courthouse or the defendant house also. The procedure adopted by the court is regular, irregular, improper, or unjustified. The answer to this is improper. होना चाहिए, but let's see. It can be regular or improper. So now I'll explain you the concept of substituted service. Substituted service. Now, substituted service can be done by two ways. By affixing the copy of summons on the conspicuous place where defendant resides, work for gain. Right. So next is by affixing. Next is by affixing summons on the place of court. ठीक है, या तो कॉन्स्पेशियस प्लेस ऑफ कोर्ट में चला जाएगा. सेकंड इसमें हो जाएगा where the defendant lastly resided, and third is Newspaper publication. Right? Newspaper publication is an option when the person, see, the normal mode of substitute, the services are by post, by court, by person himself, right? So when he is avoiding the service or he is managing the service, the defendant, so the court has two options. First, court has two options to substitute the service, कि वो deem कर लेते हैं कि that is served. That is, first, या तो वो summons उसके घर के बाहर लगा के, उसके घर के बाहर लगा के आ जाएंगे. सेकंड, या फिर वहां पे जहां उसका ऑफिस है, जहां पे वो या फिर वर्क फॉर गेन करता है, वहां पे उसका समन चिपका के आ जाए. अगर ये नहीं होता है तो आप ये ऑप्शन भी ले सकते हैं, कोर्ट के बाहर, कोर्ट के बाहर एक नोटिस बोर्ड होता है, वहां पे समन लग जाता है कि दीज ही इज बीइंग समन्ड इन दिस केस सो एंड सो, और लास्टली रिजाइडेड, फॉर एग्जांपल आपको उसका लास्ट घर पता है लेकिन उसने घर चेंज कर लिया, सो वहां भी ऑप्शन है कि आप वहां पे समन चिपका सकते हैं. थर्ड इज न्यूज़पेपर पब्लिकेशन in any newspaper, so that there is a announcement to public saying कि भैया he is being summoned in this case, kindly acknowledge. अगर वो आ जाता है तो well and good, नहीं आता then the court has no option, no other option but to it deemed to be served, that is deemed service. So all this is, all this is deemed service. So if a summon has been sent through post, now the person has managed it and says कि door locked है, left की report है, door locked की report है, then also it is deemed service, right? That states कि address is correct, right? 40th, where the defendant is absent at the time when the service of someone is sought to be effected on him at his residence, there being no likelihood of his ability with reasonable time and in absence of empowered agent, the service may be made on, and any adult member of his family, any adult female member of his family, a servant engaged of the defendant at his residence, or both A and B. So the answer to this is both A and B. Any female or any male. Next, when where the person summoned cannot by the exercise of due diligence be found, the summons may be served by affixing the same on the notice board of the municipal council of the gram panchayat, as the case may be. Needs consideration, but in my view it is wrong. By leaving one of the duplicates of the same for him with some adult male member of his family residing with him, and the person with whom the summons is so left shall, if so required by the summoning officer, sign a receipt therefore on the back of the other duplicate. This is correct in my view. 47, C is by affixing the same on the conspicuous place of his house, it can be done. By serving the same on the servant of the person summoned and obtain from him the acknowledgement thereof the back of the duplicate. So the summons served on the servant is not valid, but duplicates with the same with some adult member, this needs consideration, and this also needs consideration by affixing then the closest answer is this, what is asked, the same can be affixed on his residence. 42nd, where the defendant is confined in a prison, the summons shall be served by affixing outside the prison, by sending process server in the prison, by delivery of the summons to the officer in charge of the prison for service on the defendant, and by production warrant through the court. See, the production warrant is for appearance in court. Until unless is being served, he will not be there, and but production warrant is also ज़्यादातर criminal cases में रहता है. So by delivery of the summons to the officer in charge of the prison. So delivery of the summons by officer in charge. The court में again अगर कोर्ट से भी बंदा जाता है, that will also go to the civil in charge of civil prison, not he will not be allowed to enter the jail. So civil prisons के पास चले जाएंगे, तो answer is C. Next, 43rd, where the serving officer delivers or tenders a copy of the summons to the defendant personally. Serving officer, that is prison maybe, of the summons to the defendant personally or to his agent, he must require such a person to sign an acknowledgement of the service to be endorsed on the original summons. Then the copy of the summons will be delivered to the defendant. The copy of the original summons with the defendant's signature thereon will be returned to court, both A and B. The original summons with the defendant's signature thereon will be returned to the plaintiff. No, this cannot happen. But answer is A and B both, because the copy of the summons defendant will be getting and the original summons will be there with the he will sign that and that will be deposited in the court. Next, during service of summons, defendant was found absent from his residence, and within reasonable time, no chance to get back at his residence. Service of the summons will be made on servant, minor daughter, adult son, or munim. So the answer to this is adult son, any adult member of the family except servant, right? So the answer to this is adult son. Next, so with these, I have explained you the MCQs of order 1 to 5, and I hope you're clear with the concepts. Since you have any doubt regarding orders 1 to 5, you can ask them in the comment section. Now I'll be starting with orders 6 to 9, 21 and 26 concepts and MCQs of all these, since they are important from the point of view of UP Judiciary examination. Now, starting with orders 6 to 9, 21 and 26, I'll be starting with order number 6, that states pleading. Right. Now, pleading includes both plaint and written statement. So, plaint plus written statement is equal to pleading. Now, principles. First, state facts, not law. Second, material facts should be stated. Third, no evidence to be stated. Fourth, summarized form. Right? So this is what pleading is, and you have to state your facts and not law, because the judge knows the law. You have to just state what dispute and what has happened. Right? Now the facts must be all material. For example, आपने A sold B to goods, sorry, A sold goods to B. Now what has happened is कि A gave goods to B and B ordered the goods is a material fact, but B के दो बच्चे हैं, B यहाँ B की family में ये है, it is not relevant, so you do not have to complete that in your plaint. This is what your principle says. Third is no evidence to be stated. Now, if there is a bill that you have, for example, it is your invoice that has been, you are depending upon your invoice or purchase order given by the B. So you do not have to inculcate all the contents of the sale. You have to just annex it. You can annex that document, but you do not have to write the contents of the same in your plaint until and unless they are so important that you reiterate them in the plaint. All right. So this was your order 6. Now it's order 7. Order 7, that is plaint. Now in plaint, the plaint is given the order 7 tells us the structure, how a plaint should be structured. So I'll be drawing out the structure of the plaint and be telling you about the importance and important parts of the same. First, right, I'm drawing out the structure of the plaint. I'll be explaining you where it is written, how it is written, and what you have to plead, right? So I have given out you the structure of the plaint. Here I'll explain what is to be written and what is not to be written. Now, first and foremost, you have to write the name of the judge. That is, first is name of the judge. Second is your designation of the judge, right? Nomenclature is whether you're filing for the civil suit for district judge or for senior civil judge. So it can be CS for DJ or CS for SCJ, different in different courts or different states. Now, A, the plaintiff, you have to write here son of, resident of, right? You have to explain yourself. If a minor, then the representative, it has to give its own details. B, again, you have to write son of, resident of. Again, if not known, then not known, right? But son, if you do not know the name of the father of the defendant, but you have to write the name of the you can write the name of as none or not known, and but you have to write the name, the residence of the defendant. Right now, subject is suit for suit for recovery of X amount. All right. Now you have to introduce A first, second. This is third. This is fourth, fifth. This is sixth. Introduce A, introduce B. Now transaction, that is material facts. Right now, after writing all the material facts, that is, I've sold goods to B, goods ordered 10 mobile phones for selling. He has placed this order. I have sent it through bus. This is the bill. This is the statement of account, ledger, whatever you want to annex. Then you have to write the cause of action, that from when the dispute arose and from when the answer is to be the defendant is liable to answer to this honorable court, right? That is your cause of action. Then you have to write the para of the jurisdiction, of territorial jurisdiction and pecuniary jurisdiction. You have to tell the court, or the advocates will be telling the court that how the jurisdiction is made out territorially and pecuniary. Territorially is like where the cause of action is there, or the defendant resides or works for gain, or there is cause of action in total. Okay? Pecuniary is different in different states, so you have to look into that. Then the prayer, the relief you are seeking, right? So this is what the plaint says. Next shall be order 8. Order 8 is written statement. In other words, it can be said a plaint of the defendant. A plaint of the defendant. Now, the structure of the written statement is completely same as per the so the WS the WS is governed by some rules. Now, rules. See, whenever you give a reply to the plaint of the plaintiff, you have to specifically deny the allegations or averments of the right. Specific denial should be there. No evasive deny. Matlab, for example, some says it says ki A says ki A has supplied goods to B. Now B says nahi, no. So that is, this is an evasive reply. You have to give a specific denial first and then the reason that why are you denying it. Right? There should be reasons of denial. Fourth, the defendant can plead new facts and can bring into on record new facts that has been hidden by the plaintiff. Next, in the written statement, you have to actually put your case to the plaintiff and has to rebut the case of the plaintiff. Now, the concept of set off. And counterclaim. For example, A sues for 20,000, right? B says I have given 10,000. So this, the plaintiff can agree to this and say कि I am setting off my right of claiming 10,000. Now A claims 10,000. So this is set off and in very simple words. Now, same situation, A sues for 20,000, right? Now, B says, since you have sued me for 20,000, my 40,000 were due on you. So this is my counterclaim. मतलब अगर if the plaintiff say इसकी 20 का उन्होंने केस डाला है और आप कहते हो कि 10 मैं देख चुका हूं, तो 10 का केस बचा तो अमाउंट रिड्यूस हो गया. अगर ए 20 का केस डालता और आप कहते हो नहीं 40 मैंने तुझसे लेने हैं, तो दैट इज अ काउंटर क्लेम, राइट? This is counterclaim. So this was the concept of pleading, plaint, and written statement. Now we will start with the MCQs. First, pleading has been defined in Order 6, Rule 1 of the Code of Civil Procedure, Order 6, Rule 2 of the Code of Civil Procedure, Order 8, Rule 1 of Code of Civil Procedure, and Order 8, Rule 2. Its answer is Order 6, Rule 1. Order 6, Rule 1 of the Code of Civil Procedure. Next shall be pleading. Pleading means plaint or rejoinder, plaint or written statement, plaint or written statement or rejoinder, plaint alone. So the answer to this is plaint or written statement. Because I have already told you the concept of pleading. This is plaint plus WS. तो इन दोनों में से कुछ भी हो सकता है pleading. Also, I have also told कि written statement is a plaint of the defendant. Next shall be pleadings should state material facts, the law, the evidence, or any facts. The plaint should state only the material facts. Next, which of the following is or are the fundamental rules of pleading as set forth under Order 6, Rule 2 of the Code of Civil Procedure? Answer to this is every pleading must state facts and not law only. This is correct. It must state material facts only. This is also correct. It must state such facts in a concise form only. This is also correct. The answer to this, all of these. I have explained you the fundamentals of principles of the pleadings in the introductory slide. The next is what is the essence of pleadings? Plead facts, not law. Plead law, not facts. Plead facts and law, and all of the above. The answer is plead facts and not law. Simple as. Next, Civil Procedure Code pleading does not include plaint, correct? Written statement, correct? Evidence, no. Written statement, correct. So the answer to this is evidence. You cannot put your evidence in your plaint. All right. So next, a bundle of facts which taken with the law applicable to them gives the plaintiff the right to relief against the defendant. It is called plaint, written statement, cause of action, or none of these. The answer to this is cause of action, because these bundle of facts only constitute the facts of cause of action. So cause of action is like when did the time occur, or when the time occurred, the plaintiff was forced to approach the honorable court. So the answer to this is C, cause of action. Next, no evidence is required to be pleaded in written statement, writ petition, counter affidavit, or all of the above. Again, whatever you submit in court, right, in the pleadings in written format, you do not have to inculcate your evidence at any point of time, so in any proceeding. So the answer to this is all of the above. Next, ninth, which one of the following is not a rule of pleading? Plead the fact and not the law, state the law and plead the facts, plead material facts only, plead facts, not evidence. So when I was reading, I got into a tune, but no issues. Which one of the following is not a rule of pleading? Plead the fact and not the law. This is the rule. State the law and plead the fact. This is not the rule. Plead material facts, plead facts. This is correct. So the answer to this is B, that we do not have to state the law, but to plead only the material facts. Next, factum probandum means and factum probandum and factum probanda. So let's start with the concept of factum probandum. And factum probanda. So factum probandum means the fact that has to be proved. Fact to be proved. And this means surrounding facts. All right. So the surrounding facts, like मैं if I say that उस टाइम 10 बज रहे थे, तो एक assumption जाता है, presumption जाता है कि उस टाइम मेरे हाथ में घड़ी होगी या मेरे पास फोन होगा, राइट? सो कनेक्टेड फैक्ट रहता है, तो फैक्टम प्रोबेंडम तो एक्चुअल फैक्ट होता है. फॉर एग्जाम्पल, अगर मैं ये कहता हूं कि उसने मुझसे टाइम पूछा, ठीक है, और मैंने उसको टाइम बताया, तो टाइम पूछा इज अ क्या टाइम पूछा इज अ फैक्ट टू बी प्रूव्ड, राइट? और उसने घड़ी पहनी थी या फोन था, दैट इज द सराउंडिंग फैक्ट दैट इज टू बी गिवन वेटेज. So this is the principle of factum probandum and factum probanda. Answer to this is factum probanda means that the principal fact to be proved, right? Next, pleading must be signed by the party, by the pleader only, by the pleader and the party both, by the pleader and the successor of the, by both. 11th is C, by the pleader and the party both. Again, pleading must be signed and verified also, and verified, but verified only by party, right? Next, under order 6 rule 16, pleading can be struck on the ground that is scandalous, unnecessary, vexatious, all of the above. See, you can strike out the pleadings or you can amend the pleadings. That is unnecessary. Strike out is unnecessary, scandalous, vexatious, all of the above. These all are the uh, I would say the synonyms type kind of things. But अगर जरूरत नहीं है, material fact नहीं है, एम ही plead कर रखा है, तो वो scandalous है किसी के बारे में या vexatious है, तो it can be removed. Strike out हो सकता है. The answer to 12th is D. Next, the court may strike out any matter in any pleading which may be unnecessary, scandalous, frivolous, or vexatious, which may tend to prejudice, embarrass, or delay the fair trial of the suit, which is an abuse of the process of the court. All are correct. Then, hence, the answer is D. Next, pleading can be altered or amended. Now, altered or amended is under 6 rule 17. Order 6-17 ज़्यादा, अगर if you have practiced, it will be, it's like, it is commonly known as 6-17. And order 6 rule 17 says कि whenever the fact that couldn't be pleaded before has occurred now can be inculcated in your plaint and an application under order 6 rule 7 can be filed. Now, there are two kinds of things in amendment. Facts occurring during trial, right? Now, facts occurred before filing. Now, there are two kinds of things. For example, a fact that has occurred during the trial, so definitely it couldn't be inculcated in the plaint at the time of filing of the complaint. But those facts which could have been inculcated before filing of the complaint or plaint, it has to be specifically mentioned that why it was not pleaded then and there only. That means you have come with malafide before this honorable court. Now, in this, facts occurring during the trial will not change the course of the nature of the trial. For example, civil case is there and there is some fights. So this can be inculcated, but it shall not change the nature. May or may not. May not change the nature. All right. So these are the things. For example, if I have filed a case for, let's say, probate of a bill, right? For probate of a bill, it has been filed. Now the other party does not appear after being served, proceeded ex parte. Now what will happen? What will happen is he be given the probate first instance, second instance. What if the court notices afterwards that a probate is not possible, but a succession certificate will do? Or since letter or a letter of administration will do. But for that, the court will say if you want to withdraw this probate petition, withdraw it. Or if you want to amend the same, I will issue notice again to the defendant. Why? Because the nature of the suit has been changed. So if there is change in the nature of the suit, the trial will start from its inception again. Next, under which provision of the Code of Civil Procedure it is necessary for a party to prove that in spite of all due diligence, the matter could not be raised before the commercial commencement of the trial. Its order, again, I've already told you, you have to tell the judge specifically why it was not pleaded earlier. So the answer to this is order 6 rule 17. right? Order 6, Rule 17. Next, under Order 6, Rule 17 of the Code of Civil Procedure, the court can allow to alter or amend the proceedings to either party, to plaintiff only, to defendant only, or to only one defendant if there are more than one defendant. So it's like for either party can change the pleadings that they have pleaded, because a plaint is the pleading of the plaintiff and the WS is the plaint of the defendant. So either party. Next, voluntary amendment is provided under Order 6, Rule 7, 6, Rule 15, 6, Rule 17, 6, Rule 19. The answer to this is 6, Rule 17. The court, a party, can amend its pleading at any stage, cannot allow amendment. The court cannot allow amendment of pleadings, can allow amendment of written statement only, can allow amendment of pleading at any stage of the proceeding. Now, it is a very tricky and again a tricky situation. It says the court can allow amendment of pleading at any stage of the proceeding. This is the correct answer. Why? Because the party has the right to state what has been the dispute before the court. But now court will consider why it was not told earlier first. Second, if the party is bringing an application under Order 6, Rule 17 at the stage of final arguments, then what will happen? So if the application is frivolous and is causing hindrance in the course of justice, then it will not be allowed. But again, it can be the situation where the situation there where the facts would not be able to come before. So with giving sufficient reasons, an Order 6, Rule 17 application can be filed, and on the discretion of the judge, it may be allowed also. Next, under 6, Rule 17 of CPC, the amendment of pleading may be allowed as may be necessary for determining the real controversy between the parties, as to introduce an entirely new and inconsistent case, as to take away a right of the defendant which has occurred to him by lapse of time, as to withdraw the admission made. The answer to this is as may be necessary for determining the real controversy between the parties. For example, if an application under 6 Rule 17 comes at the stage of final arguments or after the evidence has closed. So if the reasons in the 6 Rule 17 application is legal, or you can say in interest of justice, then court would allow the same. 20. Under Order 7, Rule 17 of CPC, an application for amendment of pleadings can be allowed before the commencement of trial, after the commencement of trial, either before or after the commencement of trial, or none of the above. The answer to this is either before or after the commencement of trial, because at any stage it is not barred. 21st. Which of the following proposition is incorrect insofar as the power to permit amendment of pleadings under Order 6, Rule 17 of the CPC is concerned? Amendment of the pleadings must be allowed at any stage of the proceeding before the trial is concerned. At any stage of the proceedings before, oh, okay, no, this is not the answer, sorry. This is what mistakes we all do. Like, without reading any other option, I have tick marked because after reading at any stage of the proceeding, trial has commenced. Now, trial has commenced. Amendment which cause prejudice to the other side may not be allowed by the court. Correct. This is correct. The basic or cardinal test of deciding whether an amendment should be or should not be allowed is the correct real controversy test. The court is normally prescribed from deciding the correctness or falsity of the case in the amendment when deciding an application for amendment. Correct. So the incorrect statement, all right, we have to actually pointed out the incorrect statement. So trial has commenced or after भी हो सकता है. So the answer to this is A. Answer to this is A. A only, because right. So next shall be 22nd. For the purpose of amendment of pleadings under Order 6 Rule 17, the commencement of trial takes place at when the issues are framed, when the affidavits in evidence are filed, when the affidavits in evidence are tendered by the witness, or once cross-examination begins. Answer to this is when the issues are framed. Trial commences when the issues are framed and not when the plaint is filed. When the plaint is filed, a proceeding is started, but the actual trial commences when pleadings are complete and now issues are to be framed, right? 23rd, if a party has obtained an order to amend the pleadings under CPC, if not amended after expiration of how many days shall not be permitted to amend the same without the leave of the court? The answer to this is 14 days. This is a direct question, I knew. 24th, Order 7, Rule 1 of CPC 1908 is related to pleadings, meaning written statement, particulars to be contained in the plaint. Order 6 is pleadings, 7 is plaint, 8 is written statement. Very important. And the answer to this is particulars to be contained in plaint. 24th. 25th. It is a statement of claim, a document of by presentation of which the suit is instituted. It is called a plaint. Right? It is a plaint. Where the subject matter of the suit is immovable property, the plaint shall contain a description of the property sufficient to identify it, correct? In case where the property can be identified by the boundaries or number in a record of settlement or survey, the plaint shall specify the numbers, such boundaries or numbers. The details of owners of the property in question has to be mentioned. Subject matter is immovable property. The answer to this is both A and B. Now next, Section 27, Order 7, Rule 10 of CPC provide for return of plaint, rejection of plaint, admission of plaint, both A and B above. Answer to this is A, return of plaint. Rejection of plaint is 711. Right. 28, a plaint is liable to be returned when the plaint is on insufficiently stamped paper. Plaint is not filed in duplicate. Relief is undervalued in the plaint. Plaint is filed in a court having no jurisdiction. It has to be returned. Now the funda is the plaint is filed with no jurisdiction. In these cases, the plaints are rejected. 29. A court can return the plaint for presentation to the court in which the suit should have been instituted at the time of institution of the suit, before the framing of issues, before the trial begins, or at any stage. The answer to this is at any stage. Any stage the court thinks I do not have the jurisdiction, it can return the plaint. A court can return the plaint when the court has got no territorial jurisdiction, pecuniary, subject matter, any of the above. The answer to this is any of the above. If the any of the above is missing, then it can be returned for presentation of the same in competent court. Under CPC 1908, if the court finds at any stage that it has no pecuniary jurisdiction with respect to the subject matter of the suit, it will dismiss the suit, proceed with the suit, amend the suit, return the suit. Now it will, I would say, dismiss the suit 31st, dismiss the suit, proceed with the suit, amend the suit, or return the suit. The answer to this is it will return the suit because it has no pecuniary jurisdiction, right? Sometimes it is this is the same is confusing, right? Next, in case the suit has been instituted in a court having no jurisdiction, territorial or pecuniary, the plaint is liable to be returned. Next, Order 7, Rule 10 to 10b provides for return, admission, rejection. It's return. Whether the appeal or revisional court can return the plaint under Order 7, Rule 10 CPC after setting aside the decree. Now, no, on taking a ground with the consent of the parties, yes, it can. Return the plaint, yes. A plaint can be rejected under Order 7, Rule 10 of CPC 10A under 7 Rule 11. Now the answer to this is order, it's rejected. So the same is order 7 Rule 11. On which ground plaint cannot be rejected? Now it is talking about rejected and not returned. So where it does not disclose cause of action, it's cannot. Correct. Plaint is filed in such court which does not have jurisdiction to try the suit. This, because in this case it will be returned. Where the suit now where the plaint is not filed in duplicate, again it is all rejected. Next is 37. The court can reject the plaint under order 7 Rule 11E of CPC if it is not filed in triplicate, duplicate, quadruplicate, or only C and not A and B. Only C and it's duplicate, right? You have to file it 1+1. Next, the plaint should be filed in duplicate. This rule was inserted by CPC 1976 amendment, 2002 amendment, 2000 amendment, or none of the above. The answer to this is 2002 amendment. Now, suit was filed on 2011-2012 and it has been specifically pleaded that cause of action arose on 6-10-12. Defendant appeared and without filing WS, he filed an application under Order 711 on the ground the suit is barred by limitation. State what is correct legal position. Application under Order 7 Rule 11 CPC is not maintainable because written statement should be filed firstly. See, filing of written statement doesn't take away the right to file an application under Order 7 Rule 11 for rejection of plaint because it is a technical issue. The court has to take judicial notice of the same. So WS or no WS, 711 is maintained. Plaint shall be rejected because suit is barred by law of limitation. You cannot, this is not the question. Dismissal of application will be proper. Objection could not be decided without recording. No. Application should be allowed because plaint does not disclose correct cause of action. This can be a thing. So the answer to this is dismissal shall be proper, but objection could not be decided without recording evidence of parties. Now, for example, Order 7 Rule 11 says, see, Order 7 Rule 11 is a vast order and rule stating on the very first instance, if there is something the court has to see is whether it is maintainable, technically maintainable or not. If it is technically maintainable, see, specifically it is pleaded that cause of action is 6-10-12 and the suit is filed within 1 month only. So 3 years the limitation period is okay and it is not beyond the period of limitation. So the limitation part is over. So dismissal of application will be proper and until and unless the plaintiff is not given the right to lead his evidence, the court will not dismiss his suit without listening to him or without leading evidence. 711 says this. Until and unless there is, means the 711 law is pretty very clear. If the judge thinks that the plaintiff will not be able to prove his case, then also the court will not dismiss your suit at the very first instance on the 711 application. Right. So this is the thing. Next, 40th, mark the incorrect statement. The court must be competent to try the suit at the time of filing of the suit. Subsequent change in value does not affect the jurisdiction. It does. It is the plaintiff's valuation in the plaint that determines the jurisdiction of the court and not the amount for which ultimately the decree may be passed by the court. This is correct. This needs consideration, this para, but this is correct. 40th. Next is If the pecuniary jurisdiction of the court is 10,000 and the plaintiff files the suits for accounts and finally the court finds on taking the account that rupees 15,000 are due, the court is not deprived of a discretion to pass a decree of that amount. Correct. If the plaintiff undervalues or overvalues the claim for the purpose of choosing the forum, it is not the duty of the court to return D, because it is the plaintiff is the master of his own case, whether he overvalues or undervalues. If he undervalues, he has given the court fees on that particular jurisdiction. If he overvalues, then also he has given the court fees on that valuation. So it is not the duty of the judge, right? Exactly. Whether where the plaint is not filed in duplicate, the plaint may be returned, rejected, dismissed, admitted, rejected. 41 is clearly easy. It may be rejected. Next, a defendant can pray to the court for rejection of a plaint if the stamp writing is not clear, if it is barred by another enactment of the parliament, if the plaint is made in a foreign language, and none of the above. The answer to this is if it is barred by another enactment of the parliament, that is by another statute only. Next, a plaint shall be rejected if it does not disclose the cause of action. True. If it is filed in the wrong court, if proper parties are not added, be rejected. Rejected and returned. This is a confusion, right? So if it does not disclose the cause of action, it should be rejected. Should be, it is correct. The 43 is definitely A. If proper parties are not added, it will be given time to next, under which provision of CPC a plaint is rejected by the courts in the absence of cause of action. This is Order 7, Rule 11A. Next, 45th, when a court can reject a plaint where plaintiff fails to comply with Rule 9. This is correct. If it fails to comply with Rule 9. Next is, after rejection of plaint, whether the plaint can institute fresh suit on the same cause of action. Yes, since it is technical. On rejection of plaint under provisions of 711 Code of Civil Procedure 1908, presenting of a fresh plaint in respect of the same cause of action is barred by the principle of res judicata. Barred on its own force does not preclude the plaintiff from presenting a. Again, this is correct. Barred under Order 23, none of the above. 23 is compromise. 48. A fresh suit on the same cause of action is not barred when rejected under 711, dismissed under 9.2, dismissed under 9.3, either A, B or C. The answer to this is clearly simple. 48, it's either A, B or C. Next, on which of the following grounds a plaint will not be rejected? Not be rejected. Where the suit appears from the suit in the plaint to be barred by any law, it will be rejected. Where the relief claimed is undervalued and the plaintiff, on being required to correct the valuation within a time to fails to do so, correct, rejected. Where it does not disclose a cause of action, it will be rejected. Where it has not been presented by an urgent. Again, you can file or you can present your plaint by in person also. So it doesn't matter whether advocate is there or not. Which one of the following is newly added ground for rejection of a plaint under Order 7, Rule 11 of CPC? Non-disclosure of cause of action, undervaluation of relief claimed, barred by any law, plaint not filed in duplicate. The answer to this is plaint not filed in duplicate. Next, order rejecting plaint under 7 Rule 11 of CPC is a decree, order, deemed decree or interim order. It is a deemed decree. Under Order 7 Rule 11 of the CPC 1908, the plaint shall not be rejected where it discloses the cause of action, where the suit appears from the statement in the plaint to be barred by any law, where the plaintiff fails to comply with the same, where it is not found in duplicate. The answer is A. Where it discloses. Shall not be discloses if where it is correct. 53. A file a suit against 3 defendants. Defendant number 1 alleged that there was no cause of action against him under Order 7 Rule 11D. The plaint is to be rejected in whole, rejected in part if the cause of action is not joint and several, proceeded with against all defendants or none of the above. The answer to this is proceeded with against all defendants. Next shall be the documents on which the plaintiff relies upon in support of his claim shall be filed by him in the court along with the plaint within 7 days from the date of order by the court for issue of summons on the date fixed for framing of issues by the court at the time before the hearing of the suit. Now it has to be filed along with the plaint. Exactly. 54th A. 55. Where a plaintiff sues upon a document in his power or possession, he must produce it a copy thereof along with the plaint at the time of giving evidence, framing of issues when ordered by the court. Again, along with the plaint. The provisions are relating to particulars of written statement and counterclaim is in Order 8 of Civil Procedure. As correct. The meaning of written statement is suit of the plaintiff, suit of the defendant, answer by defendant of plaintiff's suit, answer by plaintiff, it's answer by defendant of plaintiff's suit. 57. Time limit for filing of written statement is 30 days, which may be extended up to 90 days, shall be counted from date of filing of the suit, date of first hearing fixed by the court, date of service, exact. It's date of service of the summon on the defendants. The period of limitation within which defendant shall submit his written statement is ordinarily within 60 days, always 90 days, 30 days from the or 90 days if allowed by the court. It's 59th is also 30 and 90. 30 and 60, total 90. Now 60. A defendant should be present written statement of his defense within 30 days from the service on summons on him. The said period can be extended up to 90 days. Is 30 plus 60 is equal to 90. What division formally under Civil Procedure Code 1908 has been assigned to submit the written statement after a date of service, that is 30 days. 62. In a commercial suit, the time limit of 120 days of filing of written statement can be extended if the defendant shows adequate reason for non-filing. No. Can be extended. No. It cannot. Normal suits, /30 plus 60 is equal to 90. Extendable in certain matters. Commercial, /30 plus 90 is equal to 120. Non-extendable. Right. So this is the case. It cannot be extended in any sense. Next, every allegation of fact in the plaint, if not denied specifically except as against a person under disability, shall be taken to be untraversed, admitted, proved, none of the above. It shall be admitted. The provision of specific denial is provided under its Rule 3 and 5 of Order 8. There should be specific denied, I've already told you. 65th. Provisions relating to set-off and counterclaims under Civil Procedure Code 1973 are contained in 6, 7, 8 or 9. Set-off and counterclaim is in written statement. So 8. Which of the following provisions is related with the set-off under Code of Civil Procedure? Order 8, 5, 8, 6, 8, 7, 5 or 7, 6? 8, 5 or 8, 6. See, it is in Order 7 is the, this is plaint. This is WS. Set off is in WS. The answer will be in between these two. So the answer is order 8 rule 6. Next, set off can be claimed in any suit, in a recovery of money suit, in a suit for possession in both A and B, in recovery suit only. Mark the correct options. Proposition: set off is a statutory defense to a plaintiff's action, whereas a counterclaim is a cross action. Set off is a statutory defense, correct, to a plaintiff's action, is a cross action, correct. This is correct. This is correct. Set off and counterclaim arises out of the same transaction. No, no, no. Set off should not be barred on the date of the suit, while counterclaim should not be barred on the date of filing of written statement. Claim for set off cannot exceed plaintiff's claim, correct. Whereas counterclaim can exceed claim, correct. This is correct. Both set off and counterclaim cannot exceed the pecuniary jurisdiction of the court, correct. A only, 2 only, 3 only, 3, 5, 4. So the answer is incorrect now. This is correct. This is incorrect. So the answer is 2 only. Next, in a written statement, a defendant can claim set off, counterclaim, both A and B, both A and B, and either both A and B. Set off और counterclaim दोनों ही वो claim कर सकता है, कोई दिक्कत वाली बात नहीं. A sues B on a bill of exchange of rupees 500. B holds judgment against A for rupees 1000. Two claims being both definite pecuniary demands may be set off. The illustration is given in order 8 rule 5, 8 rule 6, 8 rule 7, or none of the above. The answer to this is 8 rule 6. Set off can be legal set off, equitable set off, both A and B, none of the above. The set off is basically legally भी हो सकता है और equitable भी हो सकता है, right? Next, under order 8 rule 6 CPC, set off may be permitted if the suit of recovery is of property. No. Suit of set off claimed by the defendant is ascertained sum of money. Value of property recoverable is less than 2 lakhs. Defendant presents a written statement of the suit. Set off claimed 72 is either B or D. Set off claimed दोबारा पढ़ लेते हैं. 72B, set off claimed by defendant is a certain sum of money, or defendant presents a written statement of the suit. Set off permitted है अगर set off claimed by defendant is ascertained. It is if it is an certain sum of money. Next, 73. In which of the following cases can C set off the claim? A sues con a bill of exchange. C alleges that, A sues C on a bill of exchange. C alleges that A has wrongfully neglected to ensure C is good and is liable to pay in compensation. A sues B and C rupees 1000. The debt is due to C by A alone. A sues B and C for rupees 1000. The debt is due to C by B alone. A sues C on a bill of exchange of rupees 500. C holds the judgment against A against the recovery of debt 100. So set off 500 rupees. Set off answer is D. 74. A sues B on a bill of exchange of rupees 1000. B holds the judgment against A for rupees 1000. Pecuniary demand may be set off because both claims are definite. Claims cannot be set off because issues are different. Both A and B are correct. None of the above. Must be set off because both claims are definite. This is correct. If there is specific amount then set off is possible. Now 75th. Consider the following statements. A defendant may set up by way of a counterclaim against the claim of the plaintiff any right or claim in respect of the cause of action accruing to him. The counterclaim may be submitted by the defendant even after he has delivered his defense. This is correct. The counterclaim shall not exceed the penalization of the court. Correct. Which of the statement is given are correct? 1 and 2, 1 and 3, 2nd and 3, all these. 75th. Let's examine them again. The answer to this is this is correct. Second is correct. Definitely it is correct. तो देख लेते हैं. Yeah, 75. A defendant may set up by way of a counterclaim against the claim of the plaintiff any right or claim of the cause of action accruing to him. A defendant may set up by way of a counterclaim against the claim, the plaintiff any right or claim in respect of the cause of action. It's okay. First is correct. Second, the counterclaim may be submitted by defendant even after he has delivered his defense. तो साथ में जा सकता है, बाद में कैसे जाएगा? The counterclaim shall not exceed the pecuniary jurisdiction. This is correct. Up 75 should be 1 and 2, 1 and 3, 2nd and 3. Answer to this is all these, but okay. Since he has given his defense, there's likely chance that counterclaim is not allowed. But let's see what my answer is. All these. This is correct. Now, 76. A and B sue C for recovery of rupees 1000. C has a debt due to him by A alone. Here C can set off the debt against B, set off the debt against A, set off the debt against A and B both. Cannot set off a debt due to him by A alone. So the answer is cannot set off a debt due to him by A alone. Because here the title of the suit basically is A and B. It will be A versus A B versus C. Again, counter set off not possible. Counterclaim not possible because the dispute is between only A and C. So it can be a new suit between C versus A. Subsequent suit. Right? Next, A and B sue C for rupees 1000. C cannot set off a debt due to him from A alone. Correct. C can set off debt due to him from A alone as a matter of right. No. C can set off debt due to him from A alone with prior permission of the court. No. Okay. The answer is A only. 77th is A only. 78th now. Provisions relating to counterclaim is prescribed under the Code of Civil Procedure in Order 7 तो नहीं है. This is not the case. This is not the case. Order 8 Rule 6 of counterclaim 78 is 6A. If in any case in which the defendant sets up counterclaim, the suits of the plaintiff is stayed, discontinued, or dismissed, the counterclaim shall be stayed, nevertheless be proceeded with, may be continued with the leave of High Court, no specific provision. Nevertheless be proceeded with. 80. Which of the following deals with subsequent pleading in the Code of Civil Procedure? Subsequent pleading, that is Order 8 Rule 9, 4 13, 6 10 या 10 22. The answer is Order 8 Rule 9. Next, in a suit for recovery of rupees 25 lakhs, 25 lakhs, The defendant files a written statement and pleads that it does not owe any money to the plaintiff, but in fact, he is entitled to recover the sum of rupees 40 lakhs from the plaintiff. The defendant, however, does not file a counterclaim. Can the defendant file the counterclaim at a subsequent stage in the suit or file a fresh suit seeking recovery of 40 lakhs? See, the counterclaim and suit would be barred. Only the counterclaim would be barred. The defendant can file both either a counterclaim or a suit. The defendant's claim stands abundant. No, answer is C, because both either a counterclaim or a suit can be filed, because uska right, until and unless it is in limitation, the defendant can file counterclaim or can file a suit. 82nd, which provision specifically enables the court to pronounce judgment in case the defendant fails to file written statement or subsequent pleadings? It is Order 8, Rule 10. Order 8, Rule 10. Na? Next, 83. On failure to file the written statement, under Order 8, Rule 10 of CPC, the court may pronounce the judgment at once, may order for striking of the defense, may pass any other order, either A or B or C. The answer to this is either A, B or C. Judgment भी pronounce कर सकते हैं, defense may be striked out, and any other orders like कि and one more opportunity be given to the defendant to appear before the court. Now, if the defendant fails to file written statement, the court would hear the suit ex parte. The court may pass judgment against him. The court shall issue notice. Now, again, the court would hear the suit ex parte, right? No, it will go for ex parte when he's not appeared. Suit ex parte is not apparent. Since it is not specified, now it's written fails to file. So if the court may pass judgment against him, right? This answer is B, because see, ex parte would have been an issue, would have been a scenario where the defendant has not entered appearance. If he has entered appearance, then ex parte is not an option. Then the judgment is an option against him. Next, on default in filing of written statement, under Order 8, pronouncement of judgment is mandatory, discretionary. Discretionary Rule 10 of CPC, none of the above. The same is discretionary. When the plaintiff appears and defendant fails to file written statement despite service, the court shall pronounce judgment under Order 8, Rule 10. May either require the plaintiff to prove its case by leading evidence or pronounce judgment against the defendant depending upon the nature of the case. Shall necessarily require the plaintiff to prove its case by leading evidence, direct personal appearance of the defendant. When the plaintiff appears and the defendant fails to file written statement despite service, the answer to this would be may either require the plaintiff to prove its case by leading evidence or pronounce judgment, right? So all these are covered in this option. So this is why I have marked this B. Next, what the court can do when neither party appears when it is called for hearing, ex parte order, refer to arbitration, refer for conciliation or dismissal of suit. The same can be done with dismissal of the suit if no one is being present. Dismissal of the suit under Rule 3 of Order 9 of the Code of Civil Procedure. See, Order 9 deals with appearances of parties, right? So Order 9 in this bar a fresh suit in respect of the same cause of action, does not bar a fresh suit in respect of same cause of action, may bring a fresh suit with the leave of the High Court, and may bring a fresh suit with leave of the District Court. The answer to this is does not bar. See, where a suit is dismissed under Rule 2 or Rule 3 of Order 9 of Civil Procedure Code, plaintiff is debarred from filing fresh suit. Only remedy with the plaintiff is to seek setting aside of such order. The only remedy is to bring the fresh suit, or plaintiff may, subject to the law of limitation, bring a fresh suit or he may apply for an order to set the dismissal aside. Answer is this. Plaintiff may bring a fresh suit or he may apply for an order of setting the dismissal aside. A suit can be dismissed in default under Order 9, Rule 2 of CPC, Rule 3, Rule 8, or both B and C. The answer to this is both B and C. Now, we will see Order 9. This is appearance of parties. Appearance of parties. Assuming defendant is served. If defendant appears, WS, admission denial of documents, issues evidence. If do not appears, then proceeded ex parte evidence of plaintiff judgment. All right, this is the scenario of the appearance of parties. Now, what happens if both are not appearing? If the plaintiff is not appearing, then the suit will be dismissed as default. If the defendant is not appearing, then plaintiff will prove his case unrebutted and court will pass the judgment. A fresh suit in respect of the same cause of action is permissible where a suit is dismissed under Order 9 Rule 8, where the suit is dismissed under, see, this is the answer, where the suit abates under, where the plaintiff abandons the suit. No, it's the answer is where a suit is dismissed under Order 9 Rule 3. Next, which of the following order a court may pass under Order 9 Rule 3 CPC in a suit where neither plaintiff nor defendant appears on a fixed day of hearing? Simple. Neither plaintiff nor defendant appears. That is simple adjournment, dismissal of suit, imposition of cost, adjournment, sine die. So the answer to this is dismissal of the suit. And this can be challenged with an application, right? Choose a true statement about propositions. Propositions. Where on the fixed day it is found that summons has not been served upon the defendant and consequence of the failure of the plaintiff to pay the court fee, the court may dismiss the suit. Where neither party appears when the suit is called on for bearing, the court may make an order that the suit be dismissed. Third is where a suit is dismissed under any of the above case, the plaintiff will be barred from bringing a fresh suit. Assertion. A and 2, first and second are correct, third is incorrect. Second and third are incorrect, first is correct. First and third are correct. C. First is all there, so first is definitely correct. Now, second and third is to be seen. No? Where neither party appears. Where neither party appears when the suit is called on the bearing, the court may make an order that the suit be dismissed. Correct. dismissed under any of the above case, the plaintiff will be barred. No. If it is dismissed in default, then suit can be filed again. So answer is A. 94. A suit may be dismissed where after a summons has been issued to the defendant and returned unserved, plaintiff fails to apply for fresh summons for the period of 30 days, 60 days, 7 days, 2 months from the date of such return. Answer is 7 days. Where the summons to the defendants is returned unserved and the plaintiff fails to apply for issuance of fresh summons to the defendant within 7 days of the return, the suit of the plaintiff is liable to be rejected under Order 7 Rule 11, dismissed under 9 Rule 2 of the CPC, dismissed under 9 Rule 5 of the CPC, or any of the, or either A or B or C. The answer to this is dismissed under Order 9 Rule 5. Now, an application under Order 9 Rule 7 of the CPC can be made within 60 days of the order, 30 days of the order, at any time or before the next date of hearing, anytime during the pendency of the tort, anytime on or before the next date of hearing. Next, where the defendant appears and the plaintiff does not appear when the suit is called for hearing, and where a part of the claim is admitted, where the defendant appears and the plaintiff does not appear when the suit is called for hearing, the where a part of the claim is admitted, the court shall dismiss the whole suit, dismiss the suit so far as it relates to the remainder, pass the decree of the whole claim, and proceed ex parte against the defendant. Dismiss the suit so far as it relates the remainder. So, if plaintiff has filed for a suit of 50,000 rupees and the defendant says ki I have to pay only 25,000 only, and plaintiff doesn't appear after that, so the court will dismiss the suit, decreeing of rupees 25,000 in favor of the plaintiff. Right. So next, where a suit is wholly or partly dismissed under Order 9 Rule 8 of CPC, the plaintiff may bring the fresh suit, shall be precluded from bringing a fresh suit, may bring fresh suit with the permission of the court, and none of the above. So he shall be precluded in bringing the fresh suit. Next, a suit dismissed under Order 9 Rule 8 of CPC for non-appearance of the plaintiff can be restored under 9 Rule 9, 9 Rule 10, 9, 11, or none of the above. The answer to the same is Rule 9, Order 9, Rule 9. Next, after dismissal of suit under Order 9 Rule 8 of CPC, a fresh suit on the same cause of action under Order 9 Rule 9 of CPC is barred, is not barred under any circumstances, is not barred subject to law of limitation, none of the above. It is barred. Now, next, when the defendant is proceeded ex parte after filing written statement, the defendant cannot participate in the future proceedings. The defendant can participate in the future proceedings. The defendant to participate in future proceedings must ask for setting aside of the ex parte order, must ask, or the plaintiff has option to allow the defendant to participate. Now, the answer to this is B, because with the question ex parte after filing the written statement, it states that the defendant has filed his written statement and then he has not been appearing. For example, he is not appearing for cross-examination. Then also he has the right to participate in the argument section, or he can go, or it is not compulsory. In the option C, it is written must. So, or he can go to the higher court and get an setting aside of order in favor of him. Right. So the answer to the previous question is B. The defendant can participate in future proceedings. Next shall be, in the Code of Civil Procedure, an ex parte decree can be set aside under Order 9.5, 9.10, 9.13 or 9.11. So the answer to this is C. It can be ex parte decree or ex parte order. Decree is order is if it's ex parte decree, then order 9 rule 13. If it's order, then order 9 rule 11. Again, 103 an ex parte decree can be set aside on the ground of summons not duly served being prevented by any sufficient cause from appearance. Only A is correct, both A and B. Again, summons not served is a ground for setting aside of the decree. Prevented, again, it's the same, is a ground. Then the answer to this is D, both A and B. Next, in a suit for partition, 3 defendants were set ex parte. Preliminary decree was passed on the application of one of the 3 defendants. The court set aside the decree as against all the defendants. The order of the court is definitely legal. Because it is legal, why? Because since it has been set aside against one, that means the partition suit cannot go like that, or the partition cannot be done because the rights of the left out defendants are not fully decided. That's why the order of the court is legal. Next, where the appellant has withdrawn the appeal preferred against a decree passed ex parte, the application under Order 9 Rule 13 shall be rejected, returned, maintainable, referred for the opinion to the Honorable Court. Now the answer to this is whether the appellant has withdrawn the appeal preferred against the decree passed ex parte. So defendant has withdrawn the application. See, okay, it is maintainable. See, the defendant approaching the higher courts or the defendant filing for application under 9 Rule 13 in the same court are concurrent things and do not bar any of the other proceedings, right? So it is maintainable. Remedies available against ex parte decree include all 3: appeal, review, and application for setting aside. So answer is all of these. Which of the following remedies may be sought against ex parte decree? Only application under 9 Rule 13, only appeal under Section 96 Clause 2, or both A and B? Both A and B plus review. A civil suit was repeatedly fixed by the trial court for examination of the defendant's witness, but the said opportunity was not availed by the defendant. Therefore, on 18/11/16, when neither the defendant nor his counsel had appeared, the trial court had proceeded ex parte and heard the final arguments and reserved the case for judgment. On 28/11/16, after 10 days, the defendant had filed an application under Order 9(7) read with 151, of which is maintainable, non-maintainable, matter of description of the court, accept or not, matter or inherent power of the court to accept or not. The answer to this is non-maintainable. Same is not maintainable. Next, when an ex parte decree is passed by the defendant the defendant can file, wait a second, just wait. When an ex parte decree is passed, the defendant can file an appeal under Section 96 of CPC, can file an application under 913 to opt either A or B. D, it an application above is dismissed, can file appeal to dispute the correctness of the order passed. The answer to this is actually same. We have discussed it. It can either opt for appeal or for 913 or for review or concurrent, go for all 3. Next, an ex parte decree can be set aside on the ground that summons were not duly served, Non-appearance of defendant as copies of the documents filed were not provided to the defendant. No. Defendant refused to receive the summons and thereafter no. An ex parte decree cannot be set aside under any circumstance. Summons were not duly served. See, what happens is if the summons are duly served, then only ex parte proceedings come into picture. Until and unless summons are not served to the satisfaction of the court, availing all the remedies, including that of substituted services, then only ex parte comes into picture, otherwise not. So, since summons are not duly served, ex parte decree can be set aside. Next, when an ex parte decree is passed, the defendant would normally ask for setting aside of ex parte decree by an application under Order 913, by filing a revision petition under 115 of, by filing under Article 227, by filing an application under Order 907. The answer to this is 913. Others are not maintainable, that's why. Next is under which of the following provisions of the Code of Civil Procedure 1908 an ex parte order and ex parte decree may be set aside. Ex parte order and ex parte decree. Ex parte decree is 930 for sure. So you can see this. Order 9 Rule 7, Order 9 Rule 10, Order 9 Rule 4, Order 9 Rule 7 and Order 9 Rule 13. Answer is C. 1112 is C. Order 9 Rule 7 is ex parte order and Order 9 Rule 13 is ex parte decree. 112. So let's go back, and I think it's a wrong thing, but I'll correct it here. It's Order 9 Rule 7, right? Order 9 Rule 13 is decree. Order 9 Rule 7 is order, right? This is not the case. So I'll just remove it, and this is Order 9 Rule 7. All right. So we can move on now. Next would be 113. A suit may be dismissed under Order 9 of the Code of Civil Procedure 1908, where the summons is not served upon the defendant in consequence of the plaintiff's failure to pay costs for the service of summons. Might be correct. Where neither the plaintiff nor the defendant appears. Where plaintiff after summons returned unserved fails for 7 days to apply for fresh summons. Where on the date fixed for hearing in a suit only defendant appears and he does not admit the plaintiff's claim. 113K. So there were multiple options that were right. So a suit may be dismissed when. So we have to see what are the options available to us. The answer to this is, मेरे हिसाब से तो भैया, this is also correct, this is also correct, this is also correct, and this is also correct. So the answer to this is all of the above. And next would be 114. At the stage of evidence, counsel of the plaintiff filed an application for adjournment, which was rejected, and suit was dismissed for want of evidence. Plaintiff has a remedy to file a fresh suit, first appeal, application under Order 9 Rule 9, or the revision of the same. Answer to this is 9 Rule 9. Now, after being proceeded against ex parte, the defendant is precluded absolutely from participating in any proceeding in the suit, at liberty to join proceedings at the stage where the proceedings are pending, at liberty to join the proceedings and do all the things which it would have done had he not proceeded against ex parte without getting ex parte order set aside, or none of the above. The answer to this is at liberty to join the proceeding at the stage where the proceedings are pending. So the funda behind this is, if the defendant is ex parte of filing of written statement, then the defendant can move or appear at the stage of evidence also. So can cross-examine his witness on legal points and can argue the matter to destroy the case of the plaintiff. Next, in a suit for recovery instituted by A against B, despite the summons of suit having been duly served upon B, he did not appear on the date fixed in the summons on 1/3/1993. The court consequently on 1/3/1993 passed an ex parte order against B and listed the case for 3/4/1993 for ex parte evidence of A. B can participate in further proceedings of the case. Yes, B can seek setting aside of ex parte order if he is able to show good cause for his both A and B are correct. Yes, it is correct. Next shall be, a suit may be dismissed where summons are not served on the defendant in consequence of the failure of the plaintiff to take proper steps like filing of court fee, postal charges, or requisite number of copies of complaint. Neither party appears when the suit is called on for hearing. Plaintiff, after summons to defendant has returned unserved, fails to apply for French summons within 7 days. This is all of these. The answer to this is all of these. Next, Order 21 CPC dealing with execution of decree and orders. Order 21 starts here. So, Order 21 is execution of an order or decree. Or, alright, so next, Order 21 dealing with the execution of, now it provides for enforcement of the decree. So it is 100 and it has 106 rules. Next, 119. Largest order of the Code of Civil Procedure is Order 21. This is all famous, you know that. When a court desires that its decree shall be executed by another court, it shall send to the court, to the other court, a decree and certificate of non-satisfaction, judgment and decree, judgment and execution petition, and execution petition and certification of non-satisfaction. It is a decree and certificate of non-satisfaction. Again, in the previous videos, when I was discussing about the concept of execution, where it was, I told that where the fruits of the decree cannot be realized. For example, a case has been filed and fought in Kolkata, favored, passed in favor of the plaintiff. Now plaintiff has filed an execution of the same, where he has said that the property from where I will get my funds, it is in Kolkata. Now the property in Kolkata was not able to give the fruits of the decree. Now the decree has to be shifted to the another competent court. So that another competent court, the main court, the trial court, will send it to the another competent court with a copy of a decree and a certificate of non-satisfaction that this cannot be done or this couldn't be satisfied. The decree could not be satisfied. So next shall be, where the execution is applied within so years of the decree, issuance of notice of the application for execution of decree to judgment date is not necessary. That is 2 years. If the decree is passed, sorry, if the judgment is passed in 2023, let's say, take an example of 2020, passed in 2020 and execution is filed in 2021. So the court will not issue any notice to the judgment debtor and will proceed with the attachment or whatever the relief is claimed. But if the execution is filed after 2 years, then the notice will be there. The court will call up the judgment debtor and ask why we should not proceed against him. So if it's before 2 years, then no notice is issued. Next, 122. Under which provision of CPC execution of decree for specific performance or restitution of conjugal rights or for an injunction is provided? Order 21 Rule 30, Order 21 Rule 31, Order 21 Rule 32, or Order 21 Rule 34. The answer to this Order 31 Rule, Order 21 Rule 32. Next, a decree for restitution of conjugal rights can be executed under Order 21 CPC by detention in civil prison, either by detention in civil prison or attachment of property, detention in civil prison and attachment of property, or attachment of property. The same shall be attachment of property. Next, which of the following provisions of CPC provides for adjudication of claims and objections of attachment of property? The same is defined under Order 21 Rule 58. Next, auction purchaser shall pay full of purchase money within 7 days, 15 days, 21 days, or 30 days. The answer to this is within 15 days. Next, 126. The time prescribed for filing which of the following cannot be extended or condoned by applying provisions of Section 5 of the Limitation Act? Revision under Section 115, application for execution under 21 CPC, application for 96, 100, 104, and application for substitution under Order 22 CPC. The answer to this is application for order of execution. This is 21. It is 12 years. Next, which of the following person may not file an application for execution under Civil Procedure Code 1908, namely a decree holder, legal representative if the decree holder is dead, a person claiming under decree holder, or judgment debtor? Which of the following persons may not file an application for execution under Civil Procedure Code 1908, namely a decree holder, legal representative? Again, obviously the answer is judgment debtor. Next, where immovable property forms one estate situate within the local limits of the jurisdiction of 2 or more courts, any one court may sell the entire estate. The courts can sell only that part which is within their jurisdiction. None of the courts can sell any part of the estate. That court can sell the entire estate within whose jurisdiction majority portion of the property is situated. Now, the answer to this is any one court may sell the entire estate. Now, garnishee is a person who is, garnishee is the debtor of the judgment debtor, right? So he is the answer is C. This self-explanatory hai. See, if the judgment debtor fails to pay, then the debtor of the judgment debtor will pay. A garnishee order is an prohibiting the judgment debtor from making any payment to the judgment debtor. Correct. Directing the decree holder to take the payment from the judgment debtor's debtor. Correct. So both A and B are definitely correct. Garnishee proceedings under the Code of Civil Procedure can be instituted to enable attachment of debt, shares, and other properties not in possession of the judgment debtor, attachment of property of which the owner is unknown, only for attachment of property which cannot be estimated in terms of money, only for attachment of a share in joint family property. The answer to this is to enable attachment of debt, shares, and other property not in possession of the judgment debtor. Next, which of the following statement is correct? An attachment order may come to an end by a satisfaction of decree, setting aside or reversal of decree, dismissal of execution application for decree holder's default, death of decree holder, agreement compromise between the parties. The answer to this is A, B, C, and E, B, D, and E, B, C, D, and E, all these. Okay. So A, B, and C. So B is common, B is common, B is common. So B is common, right? So B तो सही है. Satisfaction. Which of the following statement? Attachment order may come to an end obviously by satisfaction of decree. A भी सही है, तो A is there, A is not here, A is not. So answer is, let's see. Let's also examine D also. C is a dismissal of execution application for decree holder's default, correct. Death of decree holder will not, okay. Now his legal representative will come into picture. All right. So the answer is A. Next, X obtains money decree against Y. In execution of the money decree, X attaches money belongs to Y lying with Z. Then Z is called garnishing. Again, this is the concept of garnishing only. 134 is A holds a decree against B for rupees 5,000. B holds a decree against A for rupees 3,000. Both A and B apply for execution of decree to a court which has jurisdiction to execute both decrees. The court may allow execution of A decrees of rupees 2,000. Simultaneously proceed with the execution of both decrees. B shall proceed separately with this decree or none of these. The answer to this is simple as that. A allow execution of A's decree of rupees 2,000. Right. Now, which one is not correctly matched? Institution of suit, judgment and decree. Issue of summon is correct. We have read it. Order number 5. Issue of commissions, judgment and decree. See, institution is order 4. Judgment decree is also correct. The answer is D. So, with this, we will end the, I will say, the capsule number 4 of CPC. In this video, I have covered all important orders of CPC that are relevant for your UP Judiciary examination. I hope you do well. All the best for your preliminary examinations, and I hope you liked this video. Thank you so much for watching till the end. Thank you so much.